What's up, people? It's Supreme Decisions here, and today I'm actually at the site of a hospital here in Houston. But I want to give you a context of something because the reason why I'm here is actually for a completely different reason. Let's start off with that. But today I wanted to go over something because I had someone call me and ask for help in regards to a situation where there was custody of a child that was lost. And in the midst of doing that, there were certain activities that was done by the hospital or and in conjunction with other state associates. Now, what happened is generally most of us don't think about, an injury to a child. And unfortunately, most videos that I do that actually, or even my podcast that I do that speak of the protecting of children, hell, anything that has to do with children other than child support don't get a whole lot of views, don't get a whole lot of listens, because most people don't care until it happens to them. But when I give you these cases, it's because this is actually something that's important. It's something that's needed. It's also something that is deemed in a midst of where the legal system itself abuses context. Now, in this case, I want to give you a couple of circumstances where there can be a change of custody or an emergency removal. And one of those, in every state, the motion must allege facts that support at least one of the following circumstances. And when we're talking about these motions, these are things that are presented to a court to remove a child from a parent or the custody of a guardian. But I want you to keep in mind also, I'm going to put a Supreme Court case. It'll probably be here or at least referenced around me, where I'll probably do a freeze frame or something. But I want you to understand the parental rights is the highest rights given. So there must be valid reasoning in order for something to have that changed. And generally when you have the outsiders looking in, there must be things that are done in a proper manner. Now, there are risks that come with this. But those, when you're talking about the change of custody, you're also talking about custody changes that are done via emergency because of something that is either referenced from the hospital, because they do work as a direct advocate for certain situations, and they are direct lines to either what you would deem as social services or the police. In most cases, it's the police, and the police then have the direct line to social services. But either way, these are the circumstances, and the one thing that you must recognize is the verbiage. I speak constantly about words have power. The verbiage is what gets everybody in the most trouble. Because when we're talking about the child faces imminent risk. Now that, I'm going to put the definition in. Imminent risk of substantial bodily injury or death, sexual harm, extreme emotional harm, being taken from the jurisdiction, or basically the child is where they're being taken directly by someone else to another city, state, or location without the permission of the actual guardian or parent. When it's done, again, via the hospital, these are actions where, because even in my situation, I was in a car wreck, and one of the things in the car wreck, I had a minor child in the car with me. I was taken to one hospital, the child was taken to another hospital, technically two separate jurisdictions. But at the same time, there could have been other things that went along with that. Just so happened it didn't at that point. But if you have a situation where the child is, there's an injury report like a broken arm, or actually multiple or consistent injury to a child, these are red flags, and they're also things that alert certain people to be in there, because while they often say they are there for the safety of the child, they are actually there for the destruction of the family dynamic. Yes, I said it. They're there not for the safety of the child, because we hear about the actual entities where the children go has nothing to do with child safety or even child enrichment. It is strictly for the detriment of the actual family structure. But here's the thing that you must keep in mind, which must be present. So these are what they would call the requirements of an emergency ex parte petition. I'm actually going to put the definition of ex parte up because, again, some of these words are going to hit you, but at the same time, they are necessary, because even these definitions that gives you the constant idea of what it is that I'm speaking of. Because as I told you, even the newer videos, I'm going a little bit more in depth. So in order to understand where I'm at, you must go back to where I began. Because these, as I go along, I'm going to speak more fluently regarding the cases that I've already spoken about, the ideals that I've already spoken about, and the application of things that I'm now in a manner of putting them together. What a court must have to consider emergency custody petitions, the following documents must be provided. Because again, these are not optional. Here's the great part about this. This plays into your actual context for discovery. So each one of these documents must be present in discovery. They can also be asked for specifically. Because remember, I talked about when we're doing discovery, when we're asking for warrants, when we're doing certain things in the legal manner, we must be specific. The more specific you are, the less wiggle room they have, and the more you're able to lock down on the actual corruptor, so to speak. The information sheet with details about the minor child, the petitioning party, and the attorney. Because again, there must be not only a description, but the actual issue at hand regarding the minor child, the party that's actually making the complaint, and the attorney that is representing the situation itself, which in this case will be someone that is either assigned or given, that is a representative of the hospital. 2, a motion for ex parte emergency custody. The reason why they need that is because, just like I tell you, everyone that goes before the court that is going to represent the issue or argue before the court. Notice I use the word argue because there's a confrontational system and it's adversarial. Now we hear argue. These are confrontational, in your face. These are things that make this a sport. There is combat. Anyone that is going to argue before the court must do an entry of appearance. Here, that motion is done as ex parte emergency custody. Now, what you must understand, even in this, you must get this because, again, it has to pretty much lay out everything that is at question at this point for the removal. And it has to deal with one of the 4 things that I spoke about. 3, the petitioner's affidavit or sworn statement that contains evidence of the allegations in the motion. There must actually be something that is labeled, and it's generally going to be something that relates to a HIPAA situation. So it tags on to something else, because if it's going to be medical information, it's going to be something that is in a doctor's notes. I'm going to say that one more time. It's going to be something that is in a doctor's notes. Keep that in mind. 4, a motion for permanent change of custody. Now, with that, sometimes it is labeled as temporary change of custody, but the biggest issue is the change of custody, the recognition, and why the person or department that they're naming as the new custodian, guardian, or new overseer is being named. Because again, remember, when you're challenging someone, you can also challenge the character of those that are speaking against you. This falls into that category. And lastly, a notice of a 10-day return hearing. Because this is not a criminal action. This is something that is done strictly based on information they are getting from a third party. So, when you're going through that, understand there are 4 reasons they can actually even write the motion. And in that, there are 5 things you must get in discovery prior to the hearing. However, time is not your friend. The second it happens, your 10 days begins. And a lot of times they're not even held within the 10 days and not, drug out for that. They're generally something you have a hearing, and even the case of a few of the people that I've spoken to about this situation, it happened over the phone because they don't want you to actually be confrontational, and they know someone will do things that are outside their nature when it comes to dealing with their child. So keep that in mind. This is also something that can be used later in life, but just wanted to give you that introduction. And I also want to make sure you guys understand there's a process to everything that you're doing. There's a process to everything that I'm saying. One of the things that I'm giving you is not piece information, but I'm giving you a piece of information for application. Keep that in mind. There are tiers for joining the website for a reason, because everybody's not designed to stand in front of the devil and actually look them in the eye. Because it's to the point the devil does not even want confrontation. They want you to be submissive. They want you to be mind controlled. They also want you just to give them everything and not question anything. So, with that being said, keep this in mind. Keep it in rotation. Get your t-shirts. Continue supporting the channel. The links are below. You can hit the Cash App, Apple Pay, Venmo, PayPal. We're ready to go, and we're going to continue to grow. And don't forget to order your t-shirts. T-shirts going to be looking great. Lastly, don't forget to continue supporting the podcast. We're going to keep going. We're going to keep growing. Love you guys. Supreme.